Hello students, I hope that you're all doing good. In this given lecture, we're going to continue our discussion on discharge of contract. So let's begin. So with section 40, we see the idea of by whom contracts must be performed, starting in Indian Contract Act of 1872. So section 40 says that person by whom promise is to be performed. If it appears from the nature of the case that it was the intention of the parties to any contract that any promise contained in it should be performed by the promiser himself, such promise must be performed by the promiser. In other cases, the promiser or his representative may employ a competent person to perform it. It has two illustrations whereby A promises to pay B a sum of money. A may perform this promise either by personally paying the money to B or by causing it to be paid to B by another. And if A dies before the time appointed for payment, his representatives must perform the promise or employ some proper reason to do so. The second illustration says that A promises to paint a picture for B. Here A must perform this promise personally. Now section 41. I feel, student, that this section is self-explanatory with the illustrations that it has. Moving on to section 41. Effect of accepting performance from third person. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promiser. So if there's something in the contract to show that personal performance was intended, then the contract will have to be performed by the promiser himself. Sometimes what happens is that the nature of the promise is an indication by itself that the promiser must perform personally. So this usually happens in cases where the use of the personal skill of the promiser is involved. For instance, a contract to paint or sing or marry, and contracts of technical nature. In such cases, the death of the promiser puts an end to the contract, and the contract cannot be enforced against his legal representatives, neither can they enforce the promise. Ordinarily, however, the rule as laid down in section 37 is that promises bind the representatives of the promisers in case of the death of such promisers before performance. Thus, unless a contrary intention appears from the contract, a promise can be enforced against and also by the legal representatives of the seller or the buyer. So it was held in the case of Vaman Trimbak Joshi versus Changi Damodar Shimpi that there is nothing personal in the sale of goods or payments of price. Further, it has been held in the case of Kapurchand Godha versus Mir Nawab Himaya Talik Khan Azamja, where the court held that there is some English authority to the effect that discharge of a contract by a third person is effectual only if authorized or ratified by the debtor. In India, however, the words of section 41 of the Contract Act leave no room for doubt that when the appellants have accepted performance of the promise from a third person, they cannot afterwards enforce it against the promiser. Now, taking our discussion to the performance of joint promises. According to English law, if one of the several joint promisers dies, the rights and liabilities under the contract devolve upon the surviving joint promisers. The representatives of the deceased promiser neither obtain any rights nor assume any liability, unless of course they are the representatives of the last surviving promiser. So this rule may sometimes cause injustice inasmuch as the creditor loses the security of the solvency of a promiser, and section 42 of the Contract Act therefore lays down a different rule. It says on devolution of liabilities that when two or more persons have made a joint promise, then unless a contrary intention appears by the contract, all such persons during their joint lives and after the death of any of them, his representative jointly with the survivor or survivors, and after the death of the last survivor, the representatives of all jointly must fulfill the promise. So according to this section, joint promisers must during their joint lives fulfill the promise, and if any of them dies, then his representatives must jointly with the surviving promisers fulfill the promise, and so on. And on the death of the last survivor, the representatives of all of them must fulfill the promise, but this is subject to again any private arrangement between the parties. So it has been held in the case of Ganmani Anasuya versus Parvatini Amarendra Chaudhary that they may expressly or impliedly prescribe a different rule. That is, the parties to an agreement, they may expressly or impliedly prescribe a different rule, and that is alright. So another important aspect of joint promises is codified in section 43. Section 43 says that any one of joint promises may be compelled to perform. When two or more persons make a joint promise, the promisee may, in the absence of express agreement to the contrary, compel any one or more of such joint promisers to perform the whole of the promise. Each promiser may compel contribution. Each of two or more joint promisers may compel every other joint promiser to contribute equally with himself to the performance of the promise unless a contrary intention appears from the contract. So, sharing of loss by default and contribution, on that we have the idea that if any of two or more joint promiser makes default in such contribution, then the remaining joint promisers must bear the loss arising from such default in equal shares. And it has the explanation that nothing in this section shall prevent a surety from recovering from its principal payments made by the surety on behalf of the principal, or entitle the principal to recover anything from the surety on account of payments made by the principal. So it has four illustrations. Number one, A, B and C jointly promise to pay D rupees 3000. D may compel either A or B or C to pay him rupees 3000. Illustration B, A, B and C jointly promise to pay D the sum of rupees 3000. C is compelled to pay the whole. A is insolvent, but his assets are sufficient to pay one half of his debts. Here, C is entitled to receive 500 rupees from A's estate and 1250 rupees from B. Illustration C, A, B and C are under a joint promise to pay D rupees 3000. C is unable to pay anything and A is compelled to pay the whole. Here, A is entitled to receive 1500 rupees from B. Illustration D, A, B and C are under a joint promise to pay D rupees 3000. A and B being only sureties for C, C fails to pay. A and B now are compelled to pay the whole sum. They are entitled to recover it from C. So we notice that this given section lays down three rules. Number one, anyone is compellable to perform. So when a joint promise is made and there is no express agreement to the contrary, the promisee may compel any one or more of the joint promisers to perform the whole of the promise. Secondly, a joint promiser who has been compelled to perform the whole of the promise may require the other joint promisers to make an equal contribution to the performance of the promise, unless a different intention appears from the agreement. And lastly, if any one of the promisers makes a default in such contribution, then the remaining joint promisers must bear the deficiency in equal shares. So the first rule we see is that actually variance with the English common law, in that referring to the rule, the English rule as laid down in R versus Hoare and Kendall versus Hamilton, Chief Justice Strachey of the Allahabad High Court had in Muhammad Askari versus Radhe Ram Singh said, as explained in those judgments, the doctrine that there is, in the case of a joint contract, a single cause of action which can only be one suit on, is essentially based on the right of joint debtors in England to have all their co-contractors joined as defendants in any suit to enforce a joint obligation. But Section 43 allows an action to be brought against any one of the joint promisers without impleading the others as defendants. So suppose now that the creditor sues only one joint promiser, can he then subsequently sue the others? So according to English law, he cannot. But what is the position in India? Well, according to Chief Justice Strachey, there is no such bar in the words of Section 43, and therefore a subsequent suit against other promisers should be allowed to proceed. Now, talking about the idea that is mentioned in Section 44, release of one joint promiser. So the creditor is also given the right to release any one of the joint promisers from his liability, and this does not discharge the others from their liability. So Section 44 says, effect of release of one joint promiser. where two or more persons have made a joint promise, a release of one of such joint promisers by the promisee does not discharge the other joint promiser or joint promisers, neither does it free the joint promiser so released from responsibility to the other joint promiser or joint promisers. So this also marks a departure from the English common law, according to which a discharge of one joint promiser amounts to a discharge of all, unless the creditor expressly preserves the right against them. Section 45 says devolution of joint rights. When a person has made a promise to two or more persons jointly, then, unless a contrary intention appears from the contract, the right to claim performance rests as between him and them, with them during their joint lives, and after the death of any of them, with the representatives of such deceased person jointly with the survivor or survivors, and after the death of the last survivor with the representatives of all jointly. So it has an illustration where A, in consideration of 5,000 rupees, lent to him, and B and C promises B and C jointly to repay them that sum with interest on a day specified. Here B dies. The right to claim performance rests with B's representative jointly with C during C's life, and after the death of C with the representatives of B and C jointly. So in relation to this section, the Supreme Court has held in the case of Jahar Roy versus Premji Bhimji Mansata, where a joint promisee refused to join as a co-plaintiff, he was to be taken on record as pro forma defendant. The court, as it held, cannot compel any person to be a plaintiff if he does not want to be so. Time and place for performance, as mentioned in section 46 to section 50. So section 46 says time for performance of promise when no application is to be made and no time is specified. Where by the contract a promiser is to perform his promise without application by the promisee and no time for performance is specified, the engagement must be performed within a reasonable time. So it has an explanation attached that says that question what is a reasonable time is in each particular case a question of fact. Now in relation to this explanation, I would like to discuss with you a question which was asked in UPPCSJ examination 2012. It said, it was a pretty direct question. It said, a reasonable time for the performance of a contract is a question of, and as you can say right now without looking at the options, fact. It is a question of fact as mentioned in the explanation of section 46. So section 47, it says time and place of performance of promise where time is specified and no application to be made. When a promise is to be performed on a certain day and the promiser has undertaken to perform it without application by the promisee, the promiser may perform it at any time during the usual hours of business on such day and at the place at which the promise ought to be performed. So it has an illustration which says that A promises to deliver goods at B's warehouse on the 1st January. On that day, A brings the goods to B's warehouse, but after the usual hour for closing it, and they are not received. A has not performed his promise. So in the case of Nakubai Walu Dhokane versus Bhagwan Singh Prakash Chandra, where no time was specified for performance of the promise, the court said that in such cases, performance must be offered within reasonable time, and the period of 3 years as prescribed in Article 54 of the Limitation Act 1963 can be taken as the reasonable time. Section 48 says application for performance on certain day to be at proper time and place. When a promise is to be performed on a certain day and the promiser has not undertaken to perform it without application by the promisee, it is the duty of the promisee to apply for performance at a proper place and within the usual hours of business. There is an explanation. The question what is the proper time and place is in each particular case a question of fact. Section 49 says place for performance of promise when no application to be made and no place fixed for performance. When a promise is to be performed without application by the promisee and no place is fixed for the performance of it, it is the duty of the promiser to apply to the promisee to appoint a reasonable place for the performance of the promise and to perform it at such place. It has an illustration where A undertakes to deliver 1,000 pounds of jute to B on a fixed day. A must apply to B to appoint a reasonable place for the purpose of receiving it and must deliver it to him at such place. So, in relation to these sections, we need to discuss the idea of debtor where he seeks to his creditor. So, in Jose Paul versus Jose, it has been held that the common law rule is that a debtor should seek his creditor and pay him. In keeping with this rule, the section imposes a duty on a promisor to apply to his promisee for fixing a reasonable place for performance. Under the Negotiable Instruments Act of 1881, it is the duty of the payee, that is the promisee, to present the instrument for payment. And in L. N. Gupta vs. Tara Money, it was held that a promissory note executed at Bangalore stated that it would be payable at Bangalore or at any place in India. Here, the payee settled in New Delhi and demanded payment at New Delhi. So it was held that under Section 49, it was the duty of the debtor to seek his creditor and to pay him there. Lastly, in relation to this group of sections, Section 50 says performance in manner or at time prescribed or sanctioned by promisee. The performance of any promise may be made in any manner or at any time which the promisee prescribes or sanctions. It has 4 illustrations. Illustration A. B owes A rupees 2000. A desires B to pay the amount to A's account with C, a banker. B, who also banks with C, orders the amount to be transferred from his account to A's credit, and this is done by C. Afterwards, and before A knows of the transfer, C fails. So here there has been a good payment by B. Illustration B. A and B are mutually indebted. A and B settle an account by setting off one item against another, and B pays A the balance found to be due from him upon such settlement. This amounts to a payment by A and B respectively of the sums which they owed to each other. Illustration C. A owes B 2000 rupees. B accepts some of A's goods in reduction of the debt. The delivery of the goods operates as a part payment. Illustration D. A desires B, who owes him rupees 100, to send him a note for rupees 100 by post. The debt is discharged as soon as B puts into the post a letter containing a note duly addressed to A. So, in relation to these sections, there has been a case law of that of CIT versus Oakley Glass Works Limited. Here, where the creditor desired the debtor to send the money by post, the debtor was held to be discharged as soon as he posted a properly addressed and stamped letter containing the money. Now moving on to the idea of reciprocal promises, as mentioned from section 51 to section 54. So when a contract consists of an exchange of promises, they are called reciprocal promises, as you must recall from section 2F, which I discussed with you, which says promises which form the consideration or part of the consideration for each other are called reciprocal promises. So when such promises have to be simultaneously performed, then the promisor is not bound to perform unless the promisee is ready and willing to perform his promise. And this principle is laid down in section 51, which says, promisor not bound to perform unless reciprocal promisee ready and willing to perform. When a contract consists of reciprocal promises to be simultaneously performed, no promisor need perform his promise unless the promisee is ready and willing to perform his reciprocal promise. It has 2 illustrations. Illustration A. A and B contract that A shall deliver goods to B to be paid for by B on delivery. A need not deliver the goods unless B is ready and willing to pay for the goods on delivery. And B need not pay for the goods unless A is ready and willing to deliver them on payment. Illustration B. A and B contract that A shall deliver goods to B at a price to be paid by installments, the first installment to be paid on delivery. A need not deliver unless B is ready and willing to pay the first installment on delivery. And B need not pay the first installment unless A is ready and willing to deliver the goods on payment of the first installment. So, in a contract of sale for the sale of goods on payment of price, the seller need not deliver the goods unless the buyer is ready and willing to pay for the goods on delivery. And similarly, the buyer need not pay unless the seller is ready and willing to deliver the goods on payment. That is the idea of this section. So, on order of performance, the order in which reciprocal promises must be performed may be fixed by the contract, and the order so fixed must be followed. Because there must be some order which needs to be followed so as to ascertain that whose promise depends upon whose. But where the order is not expressly fixed, they will have to be performed in the order which the nature of the transaction admits. So what is this nature of transaction? And in relation to this, we need to read section 52, which says order of performance of reciprocal promises, where the order in which reciprocal promises are to be performed is expressly fixed by the contract. They shall be performed in that order. And where the order is not expressly fixed by the contract, they shall be performed in that order which the nature of the transaction requires. It has some illustrations which will help you understand this concept. Illustration A and B contract that A shall build a house for B at a fixed price. A's promise to build the house must be performed before B's promise to pay for it. Illustration B. A and B contract that A shall make over his stock in trade to B at a fixed price, and B promises to give security for the payment of the money. A's promise need not be performed until the security is given, for the nature of the transaction requires that A should have security before he delivers up his stock. This is what we mean when we say the nature of the transaction. In the case of Hashman versus Lucknow Improvement Trust, the defendant took a lease of land from the municipality of a town on condition that he pays Rs 630 for levelling charges and possession was to be delivered after levelling. The question arose whether the sum was to be paid before or after the levelling. The agreement was silent on the point. Here, the court held that in the ordinary course of business, work is not usually paid for before it is done. It is the custom in some cases for payment to be made in installments as the work progresses, but the person for whom the work is done is not expected to pay the entire cost in advance without an express agreement to that effect. On that note, section 53 lays down the principle that where one of the parties to reciprocal promises prevents the other from performing his promise, the contract then becomes voidable at the option of the party so prevented, and then he is entitled to compensation from the other party for any loss which he may sustain in consequence of the non-performance of the contract. Section 53 says, liability of party preventing event on which contract is to take effect. When a contract contains reciprocal promises and one party to the contract prevents the other from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from the other party for any loss which he may sustain in consequence of the non-performance of the contract. So it has an illustration where A and B contract that B shall execute certain work for A for 1,000 rupees. B is ready and willing to execute the work accordingly, but A prevents him from doing so. The contract is voidable at the option of B, and if he elects to rescind it, he is entitled to recover from A compensation for any loss which he has incurred by its non-performance. So liability of party preventing performance is one idea that needs to be discussed. So the same result would follow where the obstruction to performance is caused by the inadequacy of the machinery or material supplied by one of the parties. In Clenard versus Abasso Gold Mining Co., where in order to get his mine cleared of a rock, the defendant had to supply a crusher. The crusher supplied was too inadequate for the job, and this was held to be such an obstruction to performance as enabled the contractor to recover his expenses and loss of profits. Similarly, in the case of Har Prasad Chaubey versus Union of India, where a bidder to whom a coal mine was knocked down was allowed to have refund of his deposit when the coal commissioner refused to permit him to take the coal to UP, any such restriction being not present in the terms of the auction. Where the nature of the reciprocal promises is such that one cannot be performed or its performance cannot be claimed unless the other party performs this promise in the first place, then if the latter fails to perform, he cannot claim performance from the other, but must make compensation to him for his loss. Section 54 incorporates this principle. It says, effect of default as to that promise which should be performed in the contract consisting of reciprocal promises. When a contract consists of reciprocal promises such that one of them cannot be performed or that its performance cannot be claimed till the other has been performed and the promiser of the promise last mentioned fails to perform it, then such promiser cannot claim the performance of the reciprocal promise and must make compensation to the other party to the contract for any loss which such other party may sustain by the non-performance of the contract. So it has 4 illustrations. Illustration A says, A hires B's ship to take in and convey from Calcutta to Mauritius a cargo to be provided by A, B receiving a certain freight for its conveyance. A does not provide any cargo for the ship. A cannot claim the performance of B's promise and must make compensation to B for the loss which B sustains by the non-performance of the contract. Illustration B. A contracts with B to execute certain builder's work for a fixed price, B supplying the scaffolding and timber necessary for the work. B refuses to furnish any scaffolding or timber and the work cannot be executed. A need not execute the work and B is bound to make compensation to A for any loss caused to him by the non-performance of the contract. Illustration C. A contracts with B to deliver to him at a specified price certain merchandise on board a ship which cannot arrive for a month, and B engages to pay for the merchandise within a week from the date of the contract. B does not pay within the week. A's promise to deliver need not be performed, and B must make compensation. And lastly D. A promises B to sell him 100 bales of merchandise to be delivered next day, and B promises A to pay for them within a month. A does not deliver according to his promise. B's promise to pay need not be performed and A must make compensation. So on the idea of effect of one party's default, we have the case law of Nathulal versus Fulchand, whereby the plaintiff was the owner of a ginning factory constructed on agricultural land and nominally held in the name of his brother. He sold the factory to the defendant who paid half the price at once and was put in possession, the balance being payable on a fixed date. The buyer defaulted in paying up on that date and the seller rescinded the contract and brought an action for possession. So here, Justice Shah, speaking for himself, and Justice Hegde held that the nature of the contract required that the seller must have had his own name recorded as the owner and must have obtained permission from the state government for transfer of the agricultural land before he could claim for the final payment. If, therefore, under the terms of the contract, the obligations of the parties have to be performed in a certain sequence, then one of the parties to the contract cannot require compliance with the obligation by the other party without, in the first instance, performing his own part of the contract, which in the sequence of obligations is to be performed by him earlier. So long as Nathulal, in this case, that is the seller, did not carry out his part of the contract, Fulchand could not be called upon to pay the balance of the price. Now, we're going to deal with section 55 and section 56 in the next lecture because of how extensive they are. In this lecture, we're going to continue with section 57 and section 58, that is where promises comprising of legal and illegal parts exist. So, section 57 says, reciprocal promise to do things legal and also other things illegal, where persons reciprocally promise firstly to do certain things which are legal and secondly, under specified circumstances, to do certain other things which are illegal. Then the first set of promises is the contract, but the second is a void agreement. So it has an illustration whereby A and B agree that A shall sell B a house for 10,000 rupees, but that if B uses it as a gambling house, he shall pay 1,50,000 rupees for it. So here, the first set for reciprocal promises, namely to sell the house and to pay 10,000 rupees for it, is a contract. The second one, however, is a set of an unlawful object. The second set is for an unlawful object, namely that B may use the house as a gambling house, and that is why it is a void agreement. Section 57 applies to cases where two sets of promises are distinct, and when the void part of an agreement can be properly separated from the rest, the latter does not become invalid. And section 58 says alternative promise, one branch being illegal. In the case of an alternative promise, one branch of which is illegal and the other illegal, the legal branch alone can be enforced. And it has an illustration which says that A and B agree that A shall pay B rupees 1,000, for which B shall afterwards deliver to A either rice or smuggled opium. This is a valid contract to deliver rice and void agreement as to the opium. Students, that sums up this 13th lecture of the certification course. In the next lecture, I'm going to continue with time for performance as mentioned in section 55. Thank you. Take care.